William Mays, on behalf of Mr. Jalen Ross. Mr. Ross.
I got to call it though.
Oh.
Jalen Edward Ross, 260-646605A and B. Your name, sir?
Jalen Edward Ross.
Mr. Mays?
Judge, we have gone through his rights explicitly. He signed and executed an advice of rights form. Prosecuting attorney has agreed to dismiss the original charge of OWI super drunk.
Right off the bat, this case is shaping up to be one of those caught red-handed moments. A late-night stop, alcohol involved, and a defendant now standing in court facing serious driving charges. But here's the twist. The prosecution is already negotiating. Charges are being reduced, penalties are shifting, and the real question becomes, is this accountability or a strategic legal escape? Stay locked in, because what he admits next and what the judge allows might completely change how you see this case.
For an amended count of operating while visibly impaired, dismissing the PBT ticket, and also in the comments to that, which I need a copy of before I leave, they're withdrawing the implied consent refusal under Rule 257-305 sub 4, which is scheduled for next week.
Okay.
Mr. Ross understands the maximum possible penalties and is prepared to plead guilty at this time. Is that correct?
Yes, Your Honor.
All right. If you plead guilty to operating while impaired, I'm going to go ahead and dismiss the super drunk and the PBT refusal. I understand your lawyer and the prosecutor have worked this out with regard to the implied consent suspension. The impaired charge will call for, you did stay in mute, wait for my reading, right?
Stay mute, wait for him reading.
If you plead the impaired now, operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all 4 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice or rights form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no trial. Do you understand that?
I understand.
Any questions before we go on? To the charge operating while visibly impaired, how do you plead?
This right here is a classic example of plea bargaining in action, and it's more strategic than it might seem at first glance. The original super drunk charge is significantly more severe, often tied to a much higher blood alcohol level and harsher penalties. By reducing it to operating while visibly impaired, the prosecution is essentially lowering the stakes. Less jail exposure, fewer long-term consequences, and a more manageable outcome for the defendant. But here's where it gets interesting. Deals like this usually depend on cooperation, clean admission, and avoiding trial risks. So ask yourself, is this justice being served efficiently, or is the system prioritizing speed over strict accountability? And more importantly, would this deal have been offered if the circumstances were slightly worse?
Plead guilty.
Were you operating a motor vehicle on West Jefferson near Sibley in the city of Trent at 2:26 in the morning on February the 7th of 26?
Yes, Your Honor.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
I had about roughly 7 to 8 Bud Lights, and following that, 5 or 6 Jaeger bombs.
Why were you pulled over by the police?
It was aware to me that I had fallen asleep at a light with my foot on the brake pedal, and then they had woken me up and we pulled over to the side.
And you think you fell asleep, at least in part because of your alcohol consumption?
I believe it isn't drive still. My foot was on.
Yeah.
No, did you fall asleep because of the alcohol?
And that and due to being awake for 25 hours, I was recently shifted to midnights, but that is.
Okay. And when you were, okay, so you were arrested, transported to the police station and administered an intoxilizer, is that?
No, blood test, 0.19.
Blood
Manipulation
test.
purposes.
I'm sorry.
Now this is the moment that really locks everything in. The defendant openly admits to consuming a heavy amount of alcohol, 7 to 8 beers plus additional drinks, and then falling asleep behind the wheel. That's not just risky. That's a potentially deadly situation. What stands out here is how the judge carefully walks through causation. Was it alcohol or fatigue? Because legally, that distinction matters. But from a real-world perspective, both factors combined make this even more dangerous. So here's the question for you. Does being awake for 25 hours make this more understandable or even less excusable? Because at the end of the day, the responsibility doesn't disappear just because there were multiple factors involved.
Okay, and you'll stipulate that that was an accurate reading?
Yes.
Are you on probation or parole, Mr. Ross?
No.
Anybody in the world forced you to plead guilty?
No.
Plea is accepted to impaired driving. I'm dismissing the super drunk. I'm dismissing the PBT refusal. I'm going to order a screening and assessment. You'll go down the hall, you'll get your court date, which we're going to give you, and then you'll go back over to probation, fill out a questionnaire and be interviewed. I'm going to give you $1,000 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you to attend a 12-step meeting twice a week in person. My court officer is going to get into a form. Every time you go, you have to have that form signed. Every time you come to court, you have to bring that form with you. Do you understand that, sir?
Yes, Your Honor.
All right. I'll give you the court date now. We'll see if this is good with you, Mr. Mays.
Great.
What do you have for me, Heather?
Judge, we could do, how about April 23rd at 8:30?
Good that day?
23rd. I can't remember. Do I have Gardner here that morning? Is that here? I'm drawing a blank. I've got
I think that's next week, isn't it? Or the week after?
April 23rd, or I'm sorry, which one is he looking for?
23rd is kind of full. I thought for some reason I may have a hearing here already. I've got a 9:15 in Romulus.
I can give you another date. It's not a big deal. What other day do I have with Trenton?
Well, we have April 7th in the afternoon. We're getting kind of full that day.
April 7th in the afternoon. That's my mother's birthday. I want to go to, I don't want to be working too hard that day. I'm gonna go
Yeah,
home.
we're kind
Take her
of
out to
full that
lunch.
afternoon, Judge. That's why I'm trying to push everything to our next Trenton day, the 23rd.
Can you do the 23rd or not? If you can't, you
I
can't.
can do the afternoon.
We'll do it 1:00.
Okay,
We'll do it April 23rd at 1 p.m. Okay?
thank you.
There was no, actually, Heather, we don't really, there's not gonna be any restitution here. Do you want to just give me a Monday or something?
I can do that, Judge.
Let's just do a Monday.
Or you want to do a Monday, or we could even do on like one of our probation days too, a Tuesday.
Fine, either one.
How about, does April 14th work for you?
How's that?
Sure.
April 14th at 8:30.
Okay.
Okay? All right. Anything else, Mr. Mays?
No, thank you very much, Your Honor.
Have a good day. Good luck, sir. Thank you. And I'm just gonna defer, no, that's it. That's it. We're all set.